Labrīt, dāmas un kungi. Man jāsaka, ka man nedaudz jāpielabo, kas mēs esam, pirms es sāku savu prezentāciju, jo tiesību īpašniekus mēs pārstāvam vairāk vai mazāk caur pilnvarotajiem, vai nu tie ir advokāti, juristi vai patenti pilnvarotie, jo ECTA ir European Communities Trademark Association, nenorādot, vai tie ir tiesību īpašnieki, vai tie ir juristi un pārstāvji. Bet tas tādas nelielas piezīmes. Tālāk man ir jānorāda, ka prezentācija man būs angļu valodā, jo ECTA, protams, ir Eiropas līmeņa asociācija un pauž savus viedokļus angļu valodā. Divi iepriekšējie runātāji to runāja, arī izmantoja šo valodu, un, protams, visa terminoloģija un dokumenti ir šajā valodā. Līdz ar to, lai būtu konsekventi, ir vieglāk to darīt angliski. Perfect. So, coming back to the topic, sorry, I continue in English. So coming back to the topic, I will give a short overview of the legal framework of the design protection in EU. It was already mentioned by the previous speakers, but I will just highlight some important documents which need to be known. So to ensure better coexistence and consistency of the system of the design protection in individual EU countries, the EU adopted the directive in 1998. The objectives of design directive is to ensure the registered design rights give the right holder equivalent protection in all EU member states. However, limiting design protection to the territory of individual EU member states could have led to a division of the internal market. So therefore, in 2002, the regulation on community designs were adopted, and also additional regulation regarding the fees and implementation. Those registering designs are granting the exclusive rights to use the design and to prevent any third party from using it anywhere in EU for up to 25 years. The regulation also provides rule for unregistered community designs that under certain conditions can also benefit from the protection. In both cases, to be eligible for protection, design must be new and must have individual character, although it is not tested by the office in the process of registration. In 2007, the EU acceded the Geneva Act of Hague Agreement. This agreement allows applicant to register a design in countries that are party of the Hague Agreement with a single application, as it was mentioned in the first presentation, filing the application to WIPO. Accession of the agreement allows EU companies to obtain design protection not only throughout the EU with the community design, but also in the countries which are party of the Geneva Act. It simplifies procedure, reduces the costs for international protection, and makes administration easier. In 2014, the European Commission, European Commission launched a comprehensive legal and economical evaluation of the overall functioning of the design protection system in EU. So it means that since 1998 and 2002, when the community design regulation was adopted, that was the first time when Commission looked into this area. In the framework of this evaluation, the economic review of industrial design in Europe was published at the beginning in 2015, and the legal review on design protection in Europe was also published as a part of the evaluation in May 2016. Today I will, today I will focus on the analysis of the legal review, or expressing our opinion about the legal review on industrial design protection in Europe, and will not touch the other one. So the legal review on design protection in Europe examines whether harmonization has facilitated the system of design protection in the internal market, It asserts the dual system of the design protection at both national and EU level and evaluates its contribution to the Innovation Union. It's also considered whether the current legal framework requires updating in light of technological advances, as we heard about the internet influence, and also the modern requirements of users. The study analyzes the need for further harmonization within and beyond the scope of the current design directive. And as I mentioned, this was published in 2016, and so far, European Commission didn't move further with proposals or other documents produced. So ECTA evaluate this study and make their comments. It's not yet published, but it will be submitted to the European Commission. And here we are expressing our opinion about the study and, of course, the system in Europe. So methodology of the study, of the design study, was different from those which was conducted in regard to the trademark system by Max Planck Institute. And although we appreciate the linear approach of this review, we would have expected a much broader level of consultations and interviews with industries, representatives, experts, and all other interested stakeholders. However, in generally, we support the methodology of the study. As regards the terminology, the review adopts the term community design rights, or RCD, but acknowledges that under the Lisbon Treaty, the appropriate term is European Union design. We note that users of the system continue to struggle with the changes from OHIM to EU IPO and from CTM to EUTM. However, with these changes already implemented, it would be odd for design rights to retain a title which include the word community. We therefore recommend that the term EU registered design and EU unregistered design would be adopted. The review mentioned the use of this design as a marketing tool. Whilst aware of the debates at the time of implementing of the directive and regulation, we would prefer greater emphasis with a put on so-called design approach. The design approach advocates the sui generis protection of designs independent from copyright, trademark, or other rules or doctrines. It facilitates the protection of designers and the design industry as it is acknowledged the marketing value of design as a reason for its protection. The design approach could and should be referred to when interpreting the regulation and the directive. We were pleased to see confirmed that the offices of the member states who participating in the review of the study all offer e-filings of design registrations and would advocate for e-filing of design application as well as invalidity proceedings to be made available across Europe, while also maintaining traditional paper base of filings. And we do not support higher fee for paper-based applications towards the e-filings. The review addressed the effect of the parallel existing protection levels, and we strongly support the review's position that the system of parallel protection at national, EU, and international level via WIPO be preserved. It is important that applicants should have the choice in that regard. Of course, it's very much dictated by the fees, and we support the review recommendation that the fee review study be commissioned to recommend the new level of fees and structure that take account of the goal of budget balance, and that those fee levels are revealed periodically. Of course, lower fees for RCD and lower filing fees at national levels are in the interest of users of the design protection system. Fee schemes should aim to be at least balanced, without any undue disproportion and certainly any unjustified increase. At the same time, we are aware that providing a national design protection infrastructure is a resource-intensive burden for some smaller member states. Therefore, cost reduction should not result in a dangerous imbalance between RCD and national fee structure. National design filing must remain attractive for applicants. Therefore, we agree with the review finding that even a permanent surplus at EU IPO level does not in itself justify a fee reduction for RCDs. The fee review study should also examine the fees changes for multiple filings, and we support the current principle of bulk discounts for multiple filings. We do not accept that the bulk discounts benefit only for larger industries or enterprises, nor that the larger enterprises are being cross-subsidized by individuals. So we could not evaluate such findings by our practice. We support the alignment of the fee regime for RCDs and for EU designations under the Hague system so as not to distort filing behavior. We agree with the review that the renewal fees are too high and see no logical reason why the renewal fees should increase each time when RCD is renewed. The cost for EU IPO for renewing RCD does not depend on whether it is done first, second, or third time, or fourth time. This increase in fees serves only to discourage the further renewal of design rights and notion aligned with an innovative economy. So some words about Hague system, as it was already discovered this morning. The review recommends that the current parallel system of registration via national offices, MIPO and EU IPO be retained. However, the review makes no recommendation urging member states to join the Hague system in order to provide greater choice for the European designers. We consider it axiomatic in relation to user choice as well as the interests of the single market that designers have a maximum number of options for registering designs within the EU. And here I place some short overview. Of course, United Kingdom maybe should be moved from the lower part to upper part, but you can see those countries who are joined the Hague system and those who are not currently in Europe. We therefore urge the Commission to consider requiring EU member states to join to the Hague system. This would ensure, for example, that a designer in Slovakia would be in the same position as a designer in Slovenia, which is just one border distance. We therefore also urge the Commission that the member states to continue efforts at international harmonization, including through the Hague system. Although not discussed in the review, the EU and its member states have a strong presence in the international organizations, such as WIPO and ID5. And the ability to influence international harmonization is quite significant. For example, users of design protection systems should be able to use the same set of design representation within all EU member states and around the world, and this is very important for the users. Definition of the design and visibility. Generally, we take the view that amendments to the definition of essential notions such as design and to the wording of what can be protected and relating to the scope of the protection should be minimal. Such amendments should only be introduced when a clarification is necessary. Otherwise, there is a high risk of introducing uncertainties. The review deals in some details with the notion of visibility, but appears to combine two issues. Can non-visible features be protected by design law? And does a design have to be visible at certain time and in certain situations in order to be protected? This question results, in our view, from the various misunderstandings that have arisen, including as a result of incorrect court and tribunes' decisions. However, the answer to them are, in our view, comparatively simple if the regulation and directive are given a purposive construction as required by EU jurisprudence. In our view, the current state of law is correct. Design law protects the appearance only of a product or a part of the product, but design does not need to be visible at any particular point in time, and also situation. This understanding of law is risky for two reasons. The review seeks to expand design protection to non-visible features, and case law reveals a strong tendency to create an extra legal general visibility requirements for design protection. We see the need to address both such issues by the way of legislation actions. I'm seeing that I'm running out of the time, so therefore I just give a short conclusion. I will not go into details what we comment on these two questions. So regarding the first question, can non-visible features be protected by design law? Our conclusions state that contrary to the review's recommendation, we see no reason to expand design protection to non-visible features or tactile features, or to amend the definition of design in the regulation or the directive. On the contrary, we request amending the recital of regulation and the directive, noting that only visually perceivable design features are within the subject matter of the design protection. And with regard to the second question, our conclusion is that we support an amendment to the recital, specifically to note that other than for component parts or complex products, a design does not need to be visible at any particular time or in any particular situation in order to attract design protection. Exclusion of the computer programs. Our conclusion is that we would welcome a clarification, be it in a way of recital or by amending the law, to ensure that graphical user interface and parts thereof are not computer programs in the sense of articles of regulation. Case substance issues within the EU design framework regarding the disclosure rules. When in the disclosure, it was mentioned many times in your presentation that this is a very complicated issue, and we also state the same in our findings. So we consider that EU harmonized design law protect innovative designs. So therefore, this is an important question. And it is very nice to see that EU IPO launching the CP10 convergence program, because internet influencing our lives on the daily basis. And therefore, this is important to state some harmonized approach, how it will be evaluated at the national levels. So the conclusion is that we support the clarification by way of recital amendment to the effect that too obscure prior disclosure would not be held against the design. There must be true relevancy hurdle, because as mentioned also by the questions, there is a risk that some unfair practitioner or lawyer could make some artificial printouts or doing such kind of stuff. Design solely dictated by the technical function. The issue of technical function is of utmost importance for the functioning of the design protection system. We are concerned that in the current design law practice, the notion of the technical function usually is construed too broadly. In practice, it is often interpreted as it was functionality. Notably, a design feature which solely serves as a technical function is very different from a design feature which is merely functional. The technicality aspects of the notion of the decisive as it is justified for denying monopolization under design standards. However, that the technical threshold is often simply ignored. For those reasons, we advocate that notion of technical function ought to be construed narrowly. And there is our conclusions. Representation of the design. We consider that harmonization as between the EU IPO and national offices is an essential valid goal in it on of itself. Therefore, of course, we support all convergence programs, CP6, CP10, and hope that there will be more. We are happy to have an opportunity to participate in them and to express our opinion also in these groups. For designers, especially individual designers and SMEs, having a single set of requirements across the EU will aid a design filing and would lead to more designs being filed, in our opinion. We therefore support that national offices should attempt to align their practices where this is feasible in economic and institutional perspective with the cooperation programs run by EU IPO. We also agree that the current approach in relation to the number of representations under the EU IPO procedure be changed to allow a higher number of representation, or as some member states maintain, an unlimited number of representations. This promotes user choice. Indeed, for moving design, it might be that the video files better capture the design than thousands of static representations. We also consider that nowadays technology allows to file these additional features or files or whatever they are, and therefore it should be accepted by the offices. And we also agree that the 3D animated representation are helpful to understand the nature of design. Some procedural issues regarding the invalidity proceeding. The review notes that the member state study have introduced a procedure for invalidity of design right. The major distinction which exists in between those member states where invalidity proceeding can be brought before the national office, like Austria, Czech Republic, and Germany, and those in which they may only be brought before the judicial body, like Netherlands and Sweden. We agree with the review that the position should be harmonized across the EU, and that harmonization is most important toward a quick and inexpensive design invalidity system in all member states. This has already been decided with respect to trademarks, and there is no reason why this design should be different. We therefore agree that it be made mandatory for national offices to offer a quick and inexpensive invalidity procedure without the requirements of alternative resorting to the court. We further advocate that in order to review invalidity design of the national IP offices, appeal proceedings should be available to specialized courts. We also recommend amending the design directive and introduce the possibility of the counterclaims to invalidate a national design in infringement action before the court. Next one is ex parte injunction, and we agree that this issue is of high relevance and importance, but we also agree that any difficulties encountered with the member state law should be dealt with under the enforcement directive. Amending the position with respect to design without doing so with respect to other IP rights make no sense to our opinion. Then we stated some non-availability of certain actions in all member states. The review concludes, and we agree with that any changes to remedies under national law would be best directed under the revision planned for enforcement directive, and that is recommended that there'll be no change in design regulation in this regards. We noted that declaration of non-infringement would be a useful tool in the European design system. Declaration of non-infringement allows an economic operator who wishes to launch a product and who is uncertain whether a third-party design rights may hereby be infringed to apply for a court order. This could be achieved by either an amendment to the design regulation to provide for declaration of non-infringement as a matter of EU law, or alternatively to require through the enforcement directive. And especially with this internet influence nowadays, we see this as a very good tool for the designers to have the safe side when they are filing designs, and we are not able to very carefully to check all these disclosures, prior disclosures. Then we also comment on other issues, which I'm just listed here because it's a very specific one, and I will not go into the details with analyzing each of them. But in conclusion, I would like to say that our opinion about the optimization of EU design regime is that in generally the review said that there are just room for optimization is towards the 3D printings and spare parts, but we consider that it is not be limited only to this, and it should be look broader. And we also consider that with regarding the 3D printings, nowadays it's better to little bit wait how the practice will develop, and maybe to urge Commission to introduce some further studies on 3D printing impact, and not comment on that right now, and not to implement any new provisions in current law. So that in short was all. As association, it will hold an annual conference in June, so of course I kindly invite all of you to come and listen topics discovered also at this conference. Thank you for your attention. Paldies.